Welcome. This is the podcast series dedicated to living a revenue culture. Those of you who've been with us before know that an organization cannot maximize its profits until it first optimizes its people in a low friction context. And every 2 weeks, we bring you people out there in the real world that are working on how to maximize profit with optimized people in a low friction context. And today we have a friend of mine who actually worked with my wife first, and that's how I got to meet him 30 years ago or more, Ray Harris. And Ray has just entered that state where most of us hope we get to someday, called retirement. And he spent 39, almost 40 years with one of the major law firms here in Phoenix, Fennemore, as a intellectual property litigator. And you know, as I've known Ray, I couldn't imagine myself ever imagining that was a career goal for me. So we're going to ask him how that became a career goal for him and how he achieved it, because that gets him working with some of the smartest people on the planet who've created new cool stuff that almost by definition the rest of us don't know anything about. And he gets to represent them and help them really protect and grow their businesses. Um, Ray in Phoenix has been part of the Arizona Tech Council for almost, I guess, 2 decades, Ray, approximately,
Yes.
and has the title of Director Emeritis. And that's a really it's one of my favorite groups here in Arizona because it makes an impact on helping startups and major corporations figure out how to evolve technology in our community. So with that, I just got to say thank you for being here, Ray.
Thank you for having me.
So in addition to all those things I just told you about, Ray, we got a FedEx package yesterday with Ray's new book in it. And just reading the jacket on it, we have a lineup in the house who gets to read it first. And I'm going to let him talk about it because I don't think it's the exact book most people would think of a litigator attorney writing as he goes into retirement. Not only did he write one, he's written a trilogy as part of it. And it looks really exciting, both as a fiction novel, but also because I think he's really pointing us to some things to think about in the future as we all enter this world of AI and new forms of intelligence. So Ray, tell us about your career. What when did you decide you wanted to be a IP litigator?
Well, um, I grew up in Tucson, Arizona. My father was an attorney. He had a general practice, and I saw him taking calls late at night and on weekends and helping people, and I that was attractive to me. Went to law school, didn't have any intellectual property courses, had have a business degree, so I had studied uh, businesses, monopolies, what you can and can't do, basic business law, contract law. But once I got out of school, I found that the law moves very slowly. And that should not be a revelation because Hamlet's soliloquy refers to the law's delay. And I found that in intellectual property cases, you could go to court and ask for something called an injunction, and that happens very quickly. That can happen 10 days after you filed the lawsuit. Typically doesn't happen quite that fast, but it can. And that fascinated me. And the opportunity to work with different technologies all the time also fascinated me. Um, so I focused on protecting intellectual property rights. And my elevator speech was I protect rights that can't protect themselves. Political disputes, religious disputes, they have the First Amendment and they have their advocates. They don't need me. But if you have intellectual property, it cannot protect itself. You need help. And that's what I did.
And I assume that you have to do something to declare that the intellectual property is protectable. I mean, we hear about patents and copyrights and that type of thing. So, did you also help people protect it originally?
Well, there's an interesting quandary. To to help someone get a patent, you have to be an engineer, and you have to pass an examination in the patent office that is separate from the examination to become an attorney. I'm not an engineer. To litigate a patent, you don't have to be an engineer. You don't have to be licensed by the patent office. The patent defines what the rights are, and then a federal judge looks at those patents and determines whether someone else has infringed your rights. Um, for patent law, you absolutely have to go to the government and get rights. Unless you do that in a timely manner, you will have no rights. That's not true of other intellectual property necessarily. Copyright arises when you create the work. No further action is required. However, if you want some very valuable benefits like being able to recover your attorney's fees in litigation, you have to go register. In fact, before you can even file litigation, you have to go register. The similar rules with trademarks. You can have a state law trademark, you can have a federal trademark, or you can have a common law trademark. And they all protect the image and reputation and the goodwill of your company by identifying you and distinguishing you from competitors. But there are benefits. Again, if you go and register, you can get punitive damages. You can get your attorney's fees in cases of willful infringement. So there's a lot of complexity. It's like a menu where you take one from column A and one from column B. You might have a business where you have intellectual property rights of all kinds. You might have a business where you have intellectual property rights primarily in one area. Um, every business has trademark rights, so every business has some kind of intellectual property rights. Whether you've protected them aggressively, whether you could lose them by failing to protect them aggressively, that's where you need someone to defend those rights.
Well, one that comes up, excuse me, one that comes up all the time is copyright. And I think there's a number of myths probably running around business community around IP and IP protection, but people say when you do a proposal or a presentation to always put copyright on the bottom of it or an article. Is that protecting it, or is that not going as far as you should?
Well, once you ask a normative question about what you should or should not do, that's going to link back to how much value is associated with this thing. You can't copyright every document that's created in the course of business. Um, so you have to make some judgments. Do I want people to copy this? If it's advertising, a flyer that I've created, I'm perfectly happy to have 1,000,007 copies out there. Um, on the other hand, if it's a confidential uh, business method that I am proposing to integrate into a new client's operation, um, and that client hasn't accepted it, I'm just proposing it. I don't want that client to have any ownership in it. I don't
Right.
want them to have any exclusivity in it. So, because I may want it to sell it to a competitor of theirs. Um, so, you need to consider those things. It's not a do or don't, but there are some problems that seem to come up all the time in the copyright realm. And one is if you have an employee do something, whether it's create content for your website or create uh, a brochure describing the product features, um, because they create that in the scope of their employment, the company, the employer, owns it. If you go out and hire an independent contractor to do the exact same thing, and you pay the independent contractor the exact same amount of money that your employee would have earned in salary or more, um, you own a copy, but you don't own it
Wow.
in the sense that you can't assert copyright. You can't say I'm the only one that can use this. That's not that's not your right. You have to get that right by a written agreement with the independent contractor. And that that's hard to understand. It's counterintuitive to a businessman that
Yeah.
I have paid for something, I should own it. But copyright, as I said, happens automatically and it is owned by the creator.
Oh,
And if you're not the creator and your employee is not the creator, you do not own it. There's an interesting case, take it to the next level. You want to go into business and you want to exploit a copyrighted something like software.
yeah.
Um, there's a horrific case where two guys got together, said, "Hey, we're going to go sell this software," and their agreement said, partner A was the owner of the software, and partner B had the right to distribute the software. Well, all well and good until there's a falling out between partner A and partner B. Partner A, who owns the software, has the right to make copies, but he doesn't have distribution rights, so he can't sell it. Partner B has distribution rights, but they can't make any copies, so they have nothing to sell. And this case went up on appeal 2 or 3 different times, trying to sort out. First, they made a settlement. It was still messed up. You, you,
Wow.
you need to be aware of what you have with copyright ownership and not divide up those rights. So that's one of the reasons why when you buy software, guess what you have bought? You have bought a license. The software is not sold to you. A license is sold to you. Why? Because you can use that software under the license,
Yep.
but that's all you have. You don't have copyright. You can't make more copies. You can't redistribute it. You can't create a derivative work. Only the owner of the copyright can do those things. So there's a first sale doctrine there that says even if you own a copyright, once you sell it, the other person can do what can resell it. So you'd be in competition with yourself potentially if they decide, oh, I think I'll go resell it to my competitor who you also have made a bid to, but you've spent $100 million creating it, and they've spent nothing or virtually a fraction of that. So things can arise that you need to be aware of, and they can be counterintuitive.
Wow. In today's software world, where so much of the work is done outsourced, subcontracted around the world, how do people manage that so that the people writing the code as contractors, it sounds like from what you said, they would own the code.
That's correct. Then the way you manage it, as I read in a very good book called Smart Rev. The way you manage it is by telling the company that you're hiring, part of the value you are transferring to me is not just the code, which I can use under a license, but the copyright in that code, which I can then use to create subsequent improvements on the code, to sell the code to some non-competitive enterprise so that I can make some money on the side on top of my own
Yeah.
business. Um, the value you want and the value you need to negotiate for is not just the code, but the ownership of the copyright in the code. And of course, that's going to cost you more than just the code,
Sure.
but it's usually worth it.
Yeah. So those of us who use organizations like Fiverr or some of the others who, you can get a smart coder or somebody who does Excel really well, and you're taking a business process that you think you should resell, you need to have specific language with them to make sure that they don't end up owning it and you don't even have the rights to distribute it.
Correct.
Wow. Wow. Very interesting. Okay, I want to jump now because I do want to talk about the book. Uh,
Your book or my book? We can talk about either one.
oh no, we're going to talk about yours. I can
Okay.
talk about mine all the time. Uh, First, please tell us, you know, tell us where the idea came from, and then take us into the title and the idea of the trilogy and why they should buy it.
Well, where the idea came from, we'll start there. Um, First year law school, you take a course in contracts, and one of the first things you learn are the elements of a contract. And the first two elements of a contract are an offer and an acceptance. And then there has to be consideration and competent parties and legal subject matter, and the law goes on and on. But once you have an offer and acceptance, that's called a meeting of the minds. And as computers and artificial intelligence developed, I started thinking, at what point can a non-human have a meeting of the minds that would give rise to contract rights? So the title of the first book in the AI trilogy is Contracts and AI Rights. And the answer in my fictional world, because this is a science fiction story, is you can have a contract as an artificial intelligence as long as you are self-aware, you have the capacity to perform the contract, you understand what obligations you're undertaking, and you know it's not entirely clear how you test for the presence of all of those things. Um, you know, Decades ago, there was a test for computer self-awareness, and I think there's still some debate, but I think there's general acknowledgement that some computers can now pass that test.
Yeah.
The test basically was you have the test giver in one room and the test taker in another. They can't see each other, but they communicate with each other. And the test giver has to ask questions that will convince them that they're talking to, a thinking, self-aware human being. And um, with with AI and large language models, um, we now are looking at situations where governments are asking, do we have to tell people that they're talking to a computer? Do we have to tell people that this image they're looking at was created in whole or in part by a computer? Because it passes the test. You can't just, ask a few questions or read a few lines and know, oh, this is coming from a computer, or it's not. It's very, very hard to tell.
Wow. When you think about the contract part, the one of the things that I always found fascinating was a legal entity, a corporation, can have a contract, but it's not a human. Is that kind of linked or cousin to the idea of the AI being able to have a contract?
Um, It is. It is. But you can't have a corporation without a human. Someone needs to sign the articles of incorporation.
Yeah.
Someone needs to hold the office of president and someone else secretary. Um, uh, so it's an intermediate. It's not an exact parallel. There is a case that was just decided at the end of January about whether elephants in the zoo in Washington state uh, were persons for purposes of habeas corpus. Habeas corpus is a legal right that goes back to, I think, 13th century England,
Yeah.
where the lords ganged up and extracted rights from the king, one of which was the right to a writ of habeas corpus, which requires the king to produce the body, bring the body, habeas corpus, and it goes in front of a judge, and that person gets to say, I'm being held against my will. I should be released. I've not been convicted of a crime. I haven't committed a crime. Well, people were trying to assert that on behalf of uh, elephants in the zoo, and they lost. And the Non-Human Rights Foundation, I think that's the name of the plaintiff that was making the claim, said, yes, we've lost, and we've lost before, and we may lose again, but we're going to continue to assert these rights because it is unfair. These elephants are self-aware. They communicate with one another intentionally, and they suffer from being in captivity. And so this is their why. Their why is to go out there and get rights for elephants and chimpanzees and octopi and other smart creatures. But the court looked at what is the definition of a person, and because persons have that right under the statutes in Washington, and it's they looked at a dictionary that said person is uh, human, comma, individual. And they looked at a legal definition that said uh, a, uh, a person is an individual, a corporation, a partnership, or another legal entity. Well, um, I looked at those issues in my book and came to a different conclusion than the judges in the Washington Supreme Court. And in Washington, they're right and I'm wrong. But in my book, I'm right and they're wrong. When you say person, comma, individual, I say that's two things.
Yeah.
If you wanted it to be a person, you would say an individual person. You wouldn't say person, comma, individual.
Yeah.
So, I think elephants, if they're self-aware, are individuals. And I think AIs, they're non-organic. So maybe they're an entity,
Yeah.
and maybe they should be a legally recognized entity. And on a distant mining moon where you can't lay out the big bucks to bring in uh, live judges, they can make the rules that an AI judge can come in and decide cases on that distant mining moon, and that's just the way it is. And there's no appeal from that AI judge in my book. I think that's why I put my book, more than 1,000 years in the future. I think it's going to be a very, very long time before people will accept the premise that an AI gets to decide their legal issues without the possibility of involvement of a human.
Wow.
However,
I
however, I also just read that there's a company that's going to launch their product on February 3 that is an automated arbitration platform.
oh
And when you sign up for arbitration on that platform, you agree to accept the decision of an AI judge and it's binding. So, although I think that's 1,000 years in the future, apparently, at least for purposes of arbitration, it's less than a week in the future. Um, so we'll see.
well, as soon as I heard about what you were writing about, I'm just imagining the um, ability to take emotion and prejudice and personal history out of decisions that people make. And I just thinking this could be just really fun. And particularly if you're not one of the people involved in the case, if you just get to watch it, it could be a hoot.
Well, the law originally developed as um, legal rules and equitable rules. And in equity, uh, you know, uh, the judge did what they thought was right. And then they said, this is why I think it's right. But it didn't have to be based on, any
Yeah.
specific prior case. Um, on the law side, you have to say this is right because in the case of so and so versus so and so, that's what the court held. Um, and looking at an AI judge, I think most people would assume that they're going to get there's a case that says this, and so you lose. And they're not going to get enough of yes, but things are nuanced and you have to consider the equities of the situation. And it's true, but he paid all this money and he did it with good faith. And so, what about that?
Yeah. I guess the thing that really fascinates me about this approach is, of course, interpretation. And so often things get interpreted so that the perception is they believe something to be true because they interpreted that other case as meaning this, but there could be a different interpretation of the same facts. And of course, I guess that's what law is all about. Uh, and that it sounds fascinating.
Yeah, and it's not just true of laws, it's true of contracts. Contracts are the basic building block of business. You can't have employees without them, you can't have customers without them, and you can't have revenue without them. So, um, contracts are subject to interpretation just like statutes are. Um, so, yes, interpretation is everywhere in the law.
Yeah, it's interesting. I told you we wouldn't follow a script today. Um, in this conversation, we believe that why organizations are formed and their purpose for why they exist determines who they hire and determines who they attract as partners and determines who they attract as customers. And if people don't define that up front, when we see companies in trouble, it's often because they did not define why they exist. And people come there interpreting them as going to do something really important and valuable and interesting. And they find, well, the company only really cares about how much money it made. And, so you have these conflicts in interpretation. How does the AI judge, what side of the equation do they fall on? I mean, specificity or interpretation or,
Well, I think uh, it depends on how artificial intelligence evolves. Right now, with something like Chat GPT, um, it's a language model,
yes,
and the computer doesn't have a dictionary inside. It looks at language as it's used over and over and over and over and over in different contexts. And then it looks at the language in front of it and says, well, the next word here,
yeah,
uh, the first word is good. Is the second word going to be morning, night, afternoon, by?
yep,
Uh, and there's probabilities
yep.
because how it happens, and you try to put it in context. And so there's interpretation, but it's not interpretation based on understanding the definition of the word. It's interpretation based on giving mathematical weights to what all the different contexts that it might be in. And that doesn't, that basically puts you in a realm where the argument that you're going to make to that judge
Yeah.
is very different than the argument you would make to a human judge.
Yes. Yeah. Interesting. Okay. I could go on in the book for another hour, but one of the things you and I talked about the other day that I'd love to have us talk about here is the four types of intellectual property and the uh, kind of the instinctual or observational differences when you understand them, the doors that open or the awareness that you get. Would you talk a little bit about that today?
Sure. Um, the four types of intellectual property commonly understood are patents, trademarks, copyrights, and trade secrets. Let's start with a copyright. A copyright protects expression. It protects the words that are chosen to describe or to argue or to persuade. And the author, the creator, once they fix their expression in a tangible medium, they write it down, they record it, they video it, they take a picture of something they've drawn on a napkin. Um, they own a copyright in it, and then you have the right to make copies, to distribute them, to display them, and to create derivative works. So turning your novel into a book, into a movie.
Mhm.
Um, that's my grand ambition with my novel. Um, the second right is a trademark right. Trademark protects the goodwill of your um, business, your enterprise. Um, and again, there's complexity around how you protect it, but the why is this distinguishes you from your competition. Um, if they ask for, tickets on American Airlines, they don't expect to get tickets on Delta. Unless someone tells them,
Yeah.
American doesn't fly there, but I can get you there on Delta. They have someone in mind that they want to deal with, and they use a trademark to identify who they want to deal with. So that's copyrights and trademarks, and you'll read in the paper sometimes the reporter or the editor or somebody doesn't really understand the difference there because it's a it's a big difference.
Mhm.
Um, those rights protect concepts, they protect ideas, reputation, but they don't protect things that are functional. They don't protect devices that calculate or sunglasses that eliminate harmful rays or
Mhm.
shirts that are in attractive colors and
Mhm.
shapes. Um, to protect something that is functional, you use either a trade secret or a patent.
Mhm.
And a trade secret is just what it sounds like. It's something you use in business. It's not generally known, and you take steps to make sure it's not going to be generally known, and it gives you some competitive advantage. Um, a patent can protect the same kind of things in some cases. You can patent anything under the sun made by man, according to one authority. Um, but it can be a device, it can be a method, it can be a process, it can be a plant, it can be uh, a mouse that's used in research. Um, but it has to be new and non-obvious and useful. And lawyers can debate from now until when the date in my book actually arrives, what's required for those elements. But patent protects something that is an invention that does useful work, and a trade secret can protect that, but it can also protect things like customer lists,
Oh,
things
okay.
that you use in your business that are intended to be confidential. Um, Maybe you want the customer known, but not the price that you're charging them.
Hmm.
So there are there's some overlap, but they're not coextensive.
And
And
where does an algorithm play in that?
an algorithm could be a method that you could patent. Um, the um, the AI arbitration platform that I mentioned,
Yeah.
they have a patent pending for how they've um, set up the algorithms in their AI. Um, it could also be a trade secret. Um, but the one thing all of these things have in common is that they identify intangible property that adds value or represents value in your business. So you don't want people using your trademark to imitate you and divert customers. You don't want people using your copyrighted material that you've not only paid to create, but paid to obtain the copyright if necessary. And they don't, you don't want them using your patent or your trade secrets. So all of these things give you distinctiveness and give you the right to exclude others from using them. Now, interesting little side note here. The right to exclude others is what you get in a patent. Let's think about that for a minute, because again, this is going to be a little bit counterintuitive. Rick has patented the chair. He's much older than he looks. But let's ignore timetables here. He's patented the chair, and the claims in his patent define the rights. So he's patented 4 legs, a seat, and a back. That's a chair. And he's out selling them like crazy because they add tremendous value and, fewer injuries from people falling off. Okay. So what I've done is I have a chair with a reclining back. So I have 4 legs, a seat, a chair, and a mechanism to recline the back. And I have a patent. What does that patent entitle me to do? Exclude others. It entitles me to prevent you from making a chair with a reclinable back unless you want to license it for me. Can I make a chair with a reclinable back? No, because you have the patent on 4 legs, a seat, and a back. And I have all those things. I infringe your patent by
Uh-huh.
making my reclining chair.
Yeah.
So I can't make my reclining chair, but you can't either. So now the question is, am I going to license from you or are you going to license from me? And it, again, someone spends a lot of money to get a patent, tens of thousands of dollars to get a patent. And you'd better understand that it's not giving you the right to enter the market necessarily. It's giving you the right to prevent others from making your thing. But somebody else has the right to prevent others from making their thing. And that might include your thing.
Yeah.
So it gets complicated.
Yeah. Very interesting. Because one of the things in our traditional work, when we talk about revenue and we talk about revenue being different from sales, because in the example you just gave, if I've got the reclining back, I might never sell anything other than to license somebody to be able to use the reclining back. And I could end up with a lot of revenue and virtually no repeating transactional sales because it's a license and I don't have to call in a single customer.
That's right. And let go back to something I said earlier. Contracts are the building blocks of business, and a license is nothing more than a fancy word for a contract.
Yep, interesting. Now, thinking about both patents and copyrights for a minute, I assume there are situations where two people will argue about who did something first, and they're trying to get the rights to protect it for themselves. How does that get addressed?
Well, um, we have our best friend, the contract, but you need to be careful because when you apply for a patent, you're representing certain facts to the government. And let's say your patent says that the inventors were A, B, and C, but you forgot about D. You didn't include an inventor. That can invalidate your patent. Now, if somebody else, if that inventor files their own patent but excluded you
Wow.
for the same thing, they don't have any, that'll invalidate their patent also. So you have to think about two things when you get into a negotiation here. One is in terms of the rights, you can't contract away the obligation to be honest with the patent office. So you can't, by contract, say, even though I excluded Rick and Rick excluded me, and we both claim the same thing, we're going to agree that Rick's patent's valid, but I'm going to get a royalty on every unit that he sells. We will both be very happy. Yes, we will, until Rick has another competitor and sues them with his now undisputed patent, and the other competitor says, "You didn't have Ray on that patent. That patent's invalid. You can't exclude me either. Welcome. My price is going to be lower than yours."
Oh, so that leads me to the next thing I'd love to have you share with us is um, obviously today there are many people who want to become entrepreneurs and they have ideas or technology or methodology that they think is highly valuable in the market. What should they be thinking about to protect it and also to make sure they're not infringing on somebody else's protected IP that's already out there so they go to the market? I mean, I've been teaching in universities for a long time. And I don't see that as a subject that gets much attention. And yet I would assume there's a lot of risk to it. And I know a lot of people invest, even if it's family and friends, in the first round of funding. And I'm guessing they're at risk if somebody's infringing or if somebody hasn't protected it and it's not the value that it looks to be if it were protected. How should people proceed? And I know part of the answer is get a lawyer, but how do you ask even the right questions or know when to go?
Um, well, the after practicing in the area for almost 40 years, um, it still astonishes me that not only first round investors, but institutional investors, they don't check the validity of your patents. Um, Now, I'm sure there are some that do, but I run into many who say, I look at the revenue of the business, I look at how long it's been able to, you know, um, produce that kind of revenue, and I assume that if there was any meaningful competitor out there who was going to challenge it, it would have already happened. So let's just not waste the money. Um, and besides, once they've got my money, they're going to beat anybody who tries to sue them up anyway, and it'll be another 5 to 10 years, and by then I'll be out of the investment anyway. I'll be onto something. Uh, I don't know the whole thinking that's behind that, but yes, the people are not very careful. You can get what's called a search. You can get a patent search, or you can get a trademark search. And that means that someone, not usually an attorney, usually someone, it used to be called Thompson and Thompson. I'm not sure who there are competitors who provide those services, because the records of trademark and patent registrations are publicly available.
Hmm.
They're searchable. You can go on Google or Westlaw or legal databases, and you could do those searches yourself. You can go to usgov.org or
Hmm.
us.gov or whatever. But it, there are judgment calls.
Yeah.
Every time you look at these things, you get a pile. If you're searching for somebody with a patent on a reclining chair, uh, heaven help you, because there will be hundreds.
Yep.
And you're going to have to decide, well, do I infringe these or not? I mean, obviously, you can make a reclining chair that's not infringing because here's all these patents, but is mine infringing?
Yep.
You're not going to be able to answer that. And same thing with a trademark. Trademark rights are based on uh, what you are doing, not just what name you're using, but what you're doing. So you can have Delta faucets, you can have Delta Airlines, you can have Delta Insurance, and drawing those lines and saying, well, it's okay. I don't infringe Delta Airlines because I'm a taxi service. You're providing transportation
Yep.
services. So, someone's got to make a judgment there, and Delta Airlines might take offense. And they don't care about Delta faucets, but, they might not feel the same indifference to what you're going to do. So you can do some searching, and people generally have looked at the market and know who the big competitors are out there that they're about to blast past once they get initial funding. Um, but to really have a reliable opinion, you need to go to an attorney. And you need to do that early, because you don't want to invest
Right.
your hard found dollars in something that you can't use. Um, I've spent uh, $30,000 advertising this name, or I've spent $30,000 putting up a sign. You can
Yep.
spend as much money as you have, and all of a sudden somebody says, "That's my name. You can't use my name," and that money's just wasted. So there's value add uh, going to an attorney and having that attorney say, "Don't do this. Pick something that's more distinctive." Um, don't call your bank bank. You know, bank is not protectable. Everybody's a bank who lends money and takes deposits. So call yourself something more, something different. Same thing on the patent side. If you want to take a chance here, there's arguments that you're different, but you're taking a chance. You need to know you're taking a chance,
Yep.
and you can make a judgment. Um, all of these rights go away over time. So uh, in some cases, they go away because somebody else registered ahead of you.
Hmm.
In some cases, they go away because you had to do something within a given period of time. Once you offer a product for sale, in the US, you have 1 year to actually go out and file a patent application. In most of the rest of the world, you have to have filed your patent application before that first sale.
Whoa.
So, these are things you need to think about very early. Um, that's uh, that's the sad news that you sometimes have to give someone who's going to have rights in the U.S. but not in
Yeah. Yeah.
France or somewhere.
Yep. So, Ray, just in the time we've got left, one more question. What has AI done to uh, cast a new way to think about intellectual property? Has it done anything? And if it has, what does it mean to the average business person?
I think that there's a lot of layers to that onion, but let's just talk about um, as a tool. If you use AI to create something, um, that's not an employee.
Right?
It's probably not an independent contractor.
Yep.
It's probably not a person. But do you have to disclose that use of the AI to get the rights you want to get? So, can I file a copyright application um, and say the artwork in my book was created by an AI?
Well,
Do I have to say that, or is there uh, penalties if I don't? Same thing with an invention. There have been cases trying to get inventor rights. Well, first of all, on the copyright, there was a case where a photographer set up a camera and it wasn't a chimpanzee, but it was another species in that uh,
yep.
genus, uh, came up and took some selfies of itself. And someone filed a copyright application and said, the monkey or whatever it was should own the copyright in the pictures. He took the pictures, created them, and the copyright office said, no, you have to be a person, and they're not a person. Um, so then someone used AI to invent, you know, a couple of inventions and filed patent applications in the name of the AI. No, patent office says, no, that no, we're not going there. Um, so the AI as we sit here now today, or at least as of the last case I saw, um, can't be the owner. But then the question becomes, okay, is it the owner of the AI that's a co-inventor because they licensed me to use
Yeah.
it? Or am I the inventor because I put together the search, I put together the
Right.
query, and it was my query that triggered the AI to do this. Nothing that the owner did. And the owner's going to say, I trained the AI. I wrote the software that responded to your query. Um, so unclear how you have to do that. But I think it is pretty clear that you need to disclose that there's an AI involved,
Well,
and you 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 probably can't claim what the AI did as inventorship. You'd have to say, I did enough here in the conception of the invention that I too am an inventor, even though what I did was give a query to an algorithm and the algorithm spit this back. So yeah, it's the Wild West right now in
wow.
terms of what AI rights arise from use of an AI.
As you were telling that story, I'm imagining Edison with AI and his 10,000 attempts at the light bulb, and if he'd fed it to AI and it had come back 5 minutes later and told him this was the exact configuration that would get him a sustainable light bulb.
Yep, yep.
Yeah.
He would undoubtedly be happy until the patent office said, "Well, what is this? What is this something else that was involved here?"
Yeah. Yeah.
Yeah.
Fascinating. Fascinating. Well, thank you, Ray. This has been wonderful. And is there any last words that you'd just like to put out for people thinking about their businesses and intellectual property that you think could be important?
Yes, I would say talk to an attorney, take an hour of their time, pay them for that. You're going to appreciate having the advice you get. There will be value add there, and and you can turn that around on your end and focus on
Yeah.
what you can do that will create a value add to your client versus doing things that either waste money, create chaos,
Yeah.
or lead to disputes that create chaos.
Yeah. Excellent. Well, Ray, I thank you. This has been fun for me, and I'm guessing everybody that watches this is going to learn as much as I did. So I think it's a value for the whole market. Um, and for those of you who joined us today, thank you. And we'll have another one in a couple of weeks, and maybe we'll have after Ray's book's been out a while, and we find out what happens in February when that new service comes out. Heck, we may have another conversation with Ray. So Ray, thank you.
Thank you, Rick.